We now move on to defenses under the Malaysian law. Now, in case you're wondering who are these people, these are arguably some of the best defenders the Malaysian football team have ever had. Right on the right here is So Chin An. They call him the Tauke. You can see that he's got armband there. He was the captain of the team. And together with him is Santok Singh. Those were the days where we also have the players like Mukhtar Dahari and also Hassan Sani. Now, these are again names of footballers that you probably would not know. Maybe you ask your father might even hear about them. Yeah. Right. Now, in the penal code, we don't refer to defenses as we know it, right? Under the penal code, it is known as exceptions, right? General exceptions. And this is found under chapter 4 of the penal code, right? So it covers from section 76 to 106. According to the Evidence Act, the Malaysian Evidence Act, the burden of proof to prove the exceptions actually falls on the defendant. So it's quite similar to the situation for insanity in England, right? But for Malaysia, for all the defenses, the burden of proof is always on the defendant to prove on a balance of probabilities. Now, the first defense or first exception is consent, but we have done this last semester already, so we will not be covering it this semester. The next one is the defense of private defense. And this is found under section 796 to 106. And you can see that this is the exception that is covered the most in the penal code, right? 11 sections altogether as opposed to the rest. Okay, so it is a justification. This one as together with prevention of harm and compelled with threats, intoxication, and unsound mind. This will be the excuses which we'll be dealing with later. So let's look at private defense under section 796 to 106. So section 96 provides the defense. Nothing is an offense which is done in the exercise of a right of a private defense. And section 97, everyone has a right, subject to the restrictions contained in section 99, to defend his own body, the body of another person, against any offense affecting the body, or to defend the property, whether movable or immovable, of himself or of another person, against an act which is an offense falling under the definition of theft, robbery, mischief, or criminal trespass, or which is an attempt to commit theft, robbery, mischief, or criminal trespass. Right? So we will look at section 99 later. This is the restrictions on this defense. But the general rule is that everyone has a right to protect, to defend his body or somebody else's body, or to protect his property or somebody else's property. Right? When it comes to property, it's only limited to protect it from the offenses of theft, robbery, mischief, or criminal trespass, or an attempt to commit those offenses. Now we start off with the private defense of the body. Now, what is the extent? What can you do in order to protect your body or the body of another person? Well, the law allows that you can actually kill, right? Section 100 says that you can actually cause death against an assault. You can see A, B, C, D, E, F. It's quite a long list there, right? An assault which may reasonably cause the apprehension that death would otherwise be the consequence of such an assault, right? So you can kill another person in order to protect yourself from being killed, or in order to protect somebody else from being killed, or to protect yourself or somebody else from suffering grievous hurt, or to protect yourself from getting raped or somebody else from getting raped, or from suffering or being a victim of this unnatural lust, right? Or being a victim of kidnapping or abducting, or being a victim of being wrongfully confined, right? So you can actually go to the extent. This the extent doesn't mean that you automatically can cause death. You still need to fulfill the requirements. But this is the extent that you can take. You can actually cause the death of another person when you are actually protecting your body or somebody else's body. Now, any other situations which does not fall under section 100, you basically can only cause harm, right? You can only cause harm only. Now, Section 102 talks about the starting point. When can you exercise this right of private defense? And 102 provides that you can start exercising this right. It commences as soon as there is a reasonable apprehension of danger to the body that arises from an attempt or a threat to commit the offense. So you see, just like under English law, you do not have to wait for the offense to have been committed. So you can actually take preemptive steps also, right? So as long as there's a reasonable apprehension, then you can take steps to protect yourself, to defend yourself, or to defend somebody else's body. And this right continues as long as the apprehension continues. Until there's no more apprehension of danger to the body, then you will no longer have a right to exercise this defense of private defense, or the exception of private defense. Now, reasonable apprehension is therefore the key thing when it comes to private defense of the body. Now, what is reasonable apprehension? According to the case of Musa, it's not a question of whether there was an actual continuing danger, but whether there was a reasonable apprehension of such danger, right? So you do not need to show that there was an actual danger, but what is needed is that there must be a reasonable apprehension. So you don't need to show that there was actual danger, but there was an apprehension of such a danger. In the case of Musa, it was also held that there was no obligation to retreat, no duty to retreat. In fact, the case of Musa shows that you can actually pursue your adversary till he finds himself out of danger. And in the case of Musa, he actually disarmed his attacker and then he killed his attacker using the same weapon. Now, in the case of Evin, this was a case which also emphasized the importance that there must be reasonable apprehension and not that there must be an actual danger. In the case of Evin, this was a case where the accused killed the victim, who was actually a young child, but the accused had thought that it was a terrorist who was hiding. So the question is that whether was there a reasonable apprehension that the person hiding was actually a terrorist. It doesn't matter whether in fact there was no danger at all. But the question then is that this apprehension, must it be objective or must it be subjective? Now, from the word reasonable itself, we can usually deduce that we're talking about an objective test. So the apprehension must be a reasonable apprehension. It must be determined objectively. And this was what was held in the case of public prosecutor against Datuk Balwan Singh number 2. Now, this was a case of basically a road rage where the deceased, where the victim attacked the accused with a big stick, right, and started beating the accused. Now, apparently, the accused had the accused had the gun lawfully, right? Lawfully had the gun, took the gun out, and apparently the accused fired warning shots. But the victim continued hitting him with a stick, and the accused shot the victim. Now, he of course pleaded the defense to the body, and the court said that the court accepted that there was reasonable apprehension because apparently the stick that was used was a big stick. So therefore, there was a reasonable apprehension of danger to the body. Now, in the case of Yah bin Daud, right, the court held that whether it was reasonable or not, at the end of the day, it's a question of fact. So you got to look at the facts of the case, and then you got to determine it on reasonable grounds, right, objectively. This was approved by the Court of Appeal in Wong Tek Choi. However, do note that the Singapore Court of Appeal case Tan Chor Jin, this was a case where the accused took a Beretta and shot the victim, shot 6 times. I think 5 of the bullets struck the victim. And he said that he was acting in defense of his own body because apparently the victim attacked him with a chair, right? And the Court of Appeal, interestingly, in Singapore held that the test was a subjective test. Whether did he subjectively apprehend the danger or not. Now that's basically the Singapore court, and we will not follow the Singapore court. We follow the Malaysian courts, and basically in my view, the words of the penal code is quite clear, right? There must be a reasonable apprehension not a subjectively reasonable apprehension, but it must be an objectively reasonable apprehension. Now, what if there is collateral damage, or what if there's a danger of collateral damage, right? A risk of collateral damage. That means that in defending yourself, right, there could be a risk that innocent people might be injured also. Now, this is provided for under Section 106. 106 provides that if in the exercise of right of private defense against an assault, which reasonably causes the apprehension of death, the defendant is so situated that he cannot effectively exercise that right without risk of harm to an innocent person, his right of private defense extends to the running of that risk. So the right of private defense also will protect the accused from harm which will occur, which will take place against innocent people, right? Against innocent people also. Okay, if it states it very clearly that he cannot effectually exercise the right without the risk of these innocent people getting harmed. So the example that's given here, in the illustration here, is that when A is attacked by a mob, so a big group of people is coming to try to murder him, and he cannot effectually exercise his right of private defense without firing into the mob. So he can defend himself by actually shooting into the mob. However, right, he cannot fire without the risk of harming young children who are mingled in the mob. So in the crowd of people who is coming to attack him, there are also children, right? And there is a risk that if he shoots at the mob in order to defend himself, the children will also be injured or be killed. And it is said that he will commit no offense if by firing at the mob, he harms any of the children, right? So you see, if there's a group of people coming towards you, and then in this group, there are also young, innocent children. Of course, this child here doesn't look very innocent. Yeah, but yeah, if you need to shoot at the crowd and take the risk that some innocent people will be killed, then the right of private defense will actually protect you from being guilty for doing that also. Now, moving on to private defense of property, right? And again, the extent of it is that you can actually cause death. You can actually kill a person when you're defending your property. When it comes to the offense of robbery, when it comes to housebreaking by night, so not by daytime, when it comes to mischief by fire committed on any building, tent, or vessel, which building, tent, or vessel is used as a human dwelling or as a place of custody of property, or you can also cause death when you're defending property from theft, mischief, or house trespass under such circumstances as may reasonably cause apprehension that death or grievous hurt will be the consequence if such right is not exercised. Now, if it doesn't fall under 103, then it comes under 104, which is basically the extent of private defense of property is that you can cause harm on another person. So Section 105 provides the starting point for private defense of property, and it commences as soon as the reasonable apprehension of danger to property arises. So it's quite similar to the starting point for defense of body, right? Reasonable apprehension of danger to the body arises. Here, reasonable apprehension of danger to property arises. And when does it end? Okay, this is where it gets a little bit trickier, not so straightforward. It depends on which offense, right? If it's the offense of theft, then the right to protect property ends when the offender has effected his retreat with the property, or when assistance of the public authorities is obtained, or when the property has been recovered, right? So if the theft has already effected his retreat, or took the thing and ran off already, then you cannot go and start looking for the person in order to get the property back or to protect your property. What you must do then is that you must leave it to the authorities to take over. Okay, so when authorities come already, then you basically have got no right to defend the property anymore. And obviously, when the property is recovered, then the right to defend property ceases. Now, if it's a robbery, you can exercise your right to protection of property once there's reasonable apprehension of danger to property arises, but it ends when the offender no longer causes or attempts to cause to any person death or hurt or wrongful restraint, right? or there's no more fear of instant death, instant hurt, or of instant personal restraint. And when it comes to criminal trespass or mischief, the right to protect property, to defend property, ends when the offender discontinues the commission of the offense. And finally, uh, housebreaking by night. Again, the right ends when the accused discontinues the house trespass, or perhaps when the sun rises, there is no longer by night. So again, when we talk about reasonable apprehension, right? Reasonable apprehension, we are talking again about the fact that there must not be a real danger, right? And it must be tested objectively. Now, in the case of Muhammad Rafi, this was a case where the victim, so to say, he threatened to burn down a house, right? He threatened to burn down a house. However, he didn't have anything on him to carry out his threat. Right? He didn't have anything on him to carry out his threat. So it was held that there was therefore no reasonable apprehension on the defendant to actually defend his property, because the person making the threat basically has got nothing to carry out his threat with. So the court said that the threat must be imminent, it must be present, and it must be real. Right? So the threat must be imminent, present, and real. Now, the case of Amar Singh was a case where it's a theft. Do you know what the accused stole in this case? Sorry, do you know what uh, yeah, no, it's not really the accused in this case, but this involved a theft of a camel, right? And the person who stole the camel actually retreated with it already, probably sat on it and rode away with it. So therefore, there was no more right of private defense because he has effective retreat of the property that he has stole. Now, as mentioned, there is limitations to the right of private defense, and this provided for under Section 99. And Section 99 provides for 4 situations where there is no right of private defense. The first one is that if the act was done by a public servant, the public servant was acting in good faith under the color of his office, and the act does not reasonably cause apprehension of death or of grievous hurt, right? Apprehension of death or grievous hurt. Okay, so if the act actually causes apprehension of death or grievous hurt, then it will not come under Section 99, right? So you can still defend yourself. But if it's an act done by a public servant in good faith under the color of his office, doesn't cause reasonable apprehension, doesn't reasonably cause apprehension of death or grievous hurt, it doesn't have to be strictly justified by law. Okay? Right? So then there is no right to private defense. Now, explanation provides that must know or have reason to believe that the person is a public servant. So if the accused know or else have reason to believe that this intended victim or this victim is a public servant, and the public servant was actually acting in good faith under the color of his office and did not reasonably cause apprehension of death or grievous hurt, then the accused has got no right to exercise his right of private defense. Now, the second situation, 99.2, is quite similar, except that instead of the act done by a public servant, this act was done by the direction of a public servant. And again, explanation says that the accused here, the defendant, must know or has reason to believe that act was done by such direction, or unless such person states the authority under which he acts, or if his authority in writing, unless he produces such authority if demanded. So basically, the accused here must know that the act was done by the direction of a public servant. Now, the third situation is that there is no right of private defense if there is time to get protection from public authorities, right? So we're talking about the time here, time factor here. Okay, so the threat must be imminent and real. We were saying just now. But if there is time for you to get protection from public authorities, then you got no right to defend yourself. Okay, in the case of Morzuki bin Saleh, this was a case where the court held that he basically had no time. He was being attacked by a person wielding a weapon, and therefore he had to react immediately, and he validly and legally exercised his right of private defense. And the final situation is that basically this is the element of proportionality, right? There's no right to private defense if you inflict more harm than it is necessary. So as mentioned just now, just because you're allowed to to go to the extent of causing death doesn't mean that you can straight away do that, right? It must be necessary to do that, right? It must be necessary to do that. If you do that, then it's not necessary. If you inflict more harm than is necessary, then there is no right of private defense. You will be guilty for causing that harm. So you compare the case of Mozuki that we saw just now with Halim bin Din. Now, in case of Halim bin Din, the victims in this case was the Majlis Agama Islam Kedah, and they were conducting raids on close proximity, Khawat. So the victim was afraid, right? When these officers of this Majlis Agama Islam came, and he actually shot them. Now the court held that right, that was not proportionate, right? There was no need to inflict such great harm on those officers from Majlis Agama Islam Kedah. So he had no right to of private defense. So that's basically private defense under sections 96 to 106. We now move on to prevention of harm. Now, this is quite similar with the defense of necessity under English law, except here that it's necessary in order to prevent harm. Now, this is provided for under section 81 of the Penal Code. So let's look at section 81. Nothing is an offense merely by reason of this being done with the knowledge that is likely to cause harm. So you know that's going to cause harm. But if it was done without any criminal intention to cause harm, and it was done in good faith for the purpose of preventing or avoiding other harm to person or property. So there was no criminal intention to cause harm. On the other hand, it was done in good faith to prevent or to avoid harm to person or property. Right? So if the intention was not to cause harm, no criminal intention to cause harm, but the intention was out of good faith to prevent or to avoid other harm. So sometimes you may have to cause harm in order to prevent other harm to person or property. The explanation says that it is a question of fact in such a case whether the harm to be prevented or avoided was of such a nature and so imminent as to justify or excuse the risk of doing the act with the knowledge that it is likely to cause harm. So we've got to look at the fact to see whether is it proportionate or not. The harm that is to be prevented or avoided, does it justify or excuse the risk that is taken by causing the harm? Now we look at the illustrations to appreciate this better. Illustration A talks about captain of a steam vessel A, right? So that's a steam vessel. Suddenly and without any fault or negligence on his part, finds himself in such a position that if he cannot stop his vessel, he will inevitably run down a boat B with 20 or 30 passengers on board. So that's boat B there. So he needs to change the course of his vessel, right? If not, then he will actually run down boat B, and then 20 or 30 people would risk will suffer the risk of dying, okay, or at least being injured. Now, of course, it must be without negligence or any fault of the captain when he finds himself in such a position. But if he finds that by changing course, he will run a risk of running down boat C, right, with only 2 passengers aboard. Sorry, boat C is there, right, which he may possibly clear. Okay. So therefore, if A alters his course without any intention, the intention was not to run down boat B, boat C, right? But he alters his course in good faith to avoid the danger to passengers on boat B, he will not be guilty of an offense, even though he may run down boat C, right? By doing an act which he knew is likely to cause the effect. If it be found as a matter of fact that the danger which he intended to avoid was such as to excuse him from incurring the risk of running down boat C. So in a sense, boat C has got 2 passengers, right? So can you say that it's better to run down boat C and then to run down boat B, which has got more passengers. I suppose if there is really no choice, then perhaps it would be best to run down boat C instead. Unless we're going to start talking now about depends on who's in the boat, right? So it's also very difficult when we come to this kind of situations. There may be 20 or 30 people there, but what if they are criminals? So this brings to mind the movie The Dark Knight. Okay, who do you want to save? A ship full of criminals or a ship full of innocent, well, so to say innocent people, like non-criminals? Mm. Now another illustration B, A in a great fire pulls down houses in order to prevent the conflagration from spreading, right? He does this with the intention in good faith of saving human life or property. Here, if it be found that the harm be prevented was of such a nature and so imminent as to excuse A's act, A is not guilty of an offense. So if there's a fire here, and then in order to prevent it from spreading, you actually had to pull down certain structures, pull down here, say pull down certain houses, so that it will not spread further and destroy even more houses, right? So in a sense, then A will be excused. So actually, this prevention of harm is not so much a justification, but it seems to be an excuse under the penal code. Here's an example that I saw on the news. This was quite some time ago, but I thought that it clearly illustrates very well this situation, this prevention of harm. This was where at the time when the theme park was being built on Komtar. I think it's already been completed, but it's been a while since I've been to Penang. So what happened was that a fire broke out, and what the firemen did was that, you see here in this paragraph, Shamsuddin said that they had to tear down several wall structures to put out the blaze, right? So in order to stop the blaze, in order to prevent the fire from spreading, they had to pull down certain wall structures. So you cannot say that they commit mischief there, even though they actually did tear down the wall structures. A case that has been referred to when we talk about prevention of harm is the case of Ali bin Umar. This was a case where it was a ship where the rudder of the ship was suffering a defect, so the ship could not control, right, its direction, the direction where it was heading. So it was very dangerous, and what the captain did was that he decided to run the ship ashore. However, it didn't have permission to. This was an Indonesian ship, if I'm not mistaken, right? He took the ship into the Malaysian waters and ran it ashore onto Malaysian ground, right, on the Malaysian land, in order to prevent the ship from actually causing harm or even running into trouble itself. So it was held that they can use the defense of prevention of harm. But I see these examples, they are all pretty good examples when you read in the newspapers. Here is a bus driver, right? Because the bus driver realized that the brakes of the bus were faulty, right? So he had no choice but to crash into a concrete column. So he rams into this flyover column in order to stop the bus. So he clearly caused damage. However, the action saved himself and his 45 passengers, so it prevent harm to himself and the 45 passengers, right? So that's a prevention of harm. Okay. The next part will be dealing with the rest of the exceptions, which is compelled by threats. It's very similar to the defense of duress under English law, intoxication and unsound mind, which is very similar to insanity under English law.